All right, so law enforcement's been out to your house. They separated you and the other person. They presumably listened to your side of the story and the other person's side, and you ended up arrested for simple battery. What do you do next? And what are you facing? Hi, my name's Evan Watson, and I am a defense attorney here in North Atlanta, and I'd like to talk to you and give you real information about simple battery charges in Georgia. Simple battery is a misdemeanor. So misdemeanor is one of the three main levels of battery. You've got simple battery, you've got battery, and you've got aggravated battery, which is actually a felony in Georgia. But simple batteries, if you want to say it's on the lowest end of that spectrum, that's great, but it's still a very serious crime. It's a misdemeanor, and typically it's under the Family Violence Act. If you bond it out and your paper notates FVA, that's the Family Violence Act, which allows some extra things to apply to your case, some extra protections and what have you. So first things first, you've got a bond condition that probably keeps you from having any contact with the other party. Now, this doesn't matter if it's a spouse of 20 years or whether it's somebody that you've known for all of 3 days. You likely have a no contact bond. We can help you change that bond. That is a court process. When the judge saw you at first appearance and said no contact, that means no contact. But we can help attempt to change the no contact bond. We would file a motion to amend the bond, and we would put all the important facts and circumstances about your relationship to this person, what the necessity is to change the bond, so on and so forth. Typically, courts are going to require us to present evidence at a hearing before they are willing to sign off and change that bond. But we would prep you and walk you through or represent you throughout that whole process. What do you do about a family violence battery or a simple battery charge in the long run? The long run, the goal is to be proactive about things. We've seen hundreds of these cases. We've represented people on hundreds of these cases. Let's be proactive, because the court is going to want to, again, have some comfort level. Prosecutors are going to want to have a good comfort level that things are changing, that things are better, and that there's not going to be a new arrest for the same type of issue 6 months down the road. So we're always very proactive with our clients. Now, we also understand, of course, that a lot of times these things can be fabricated, right? Things are at the very minimum blown way out of proportion, all the way up to just plain fabricated by the other side. We will come in and do an absolute thorough investigation of your case. We can pull any and all records associated with what happened to you, and we will work with you to develop your best defense to the charges. Whether it goes from an agreement with the prosecutor before trial, through hearings, or all the way through trial, our team is here for you, and we have defended these cases through and through. So give us a call today if you're facing family violence or simple battery charges, and we're happy to talk to you about your best defense from the very beginning, which will be addressing bond issues, to what you and I would be doing collaboratively throughout the process, to how far we think this may go. Oftentimes, if you have no record, if this is a first incidence with something like this, which a lot of our clients it is, we're able to work out very advantageous deals and negotiations before any sort of trial would occur in order to get you and the other party back on the road you need to be on. So give us a call today, or use our contact form on our website, which is linked here, to get in contact with us, and let's have a consultation about your case.